Today, a marshal of the High Court served on the office of Vice President Bharrat Jagdeo a court order which states that default judgment, and I want to emphasize that point, default judgment was granted against Mr. Jagdeo in the sum of $20 million, along with costs in the sum of $75,000 in certain proceedings filed by Annette Ferguson. Now, this judgment was obtained apparently on the 21st of March 2021. The judgment was granted without the knowledge of Mr. Jagdeo or his lawyers, and also in their absence. Investigations revealed that in January 2020, libel proceedings were filed by Annette Ferguson against Bharrat Jagdeo. Those proceedings were served, and there was an application for injunctions also attached to the proceedings. I appeared in the High Court in those proceedings in relation to the injunctions aspect of the case. Affidavits were filed, and we had an argument. We had a date for arguments, before a High Court judge, and the arguments were heard. The judge dismissed the application for the injunction on the ground that Mr. Jagdeo has put forward a good case and that an injunction should not be granted in those circumstances and for the legal reasons advanced. So that aspect of the proceedings were disposed of, and that was around the 24th of February. Now, you would appreciate that the 24th of February was simply a week before elections, March the 2nd elections. A defense was supposed to be filed at or about the same time. But as you know, Mr. Jagdeo and I both were involved in the political campaign that was ongoing. We had several meetings with GCOM during that period of time. We had meetings with international observers. We had meetings with parties, political parties. The campaign trail was hot, and then the elections came. Then after the elections, you had this series of events that unfolded which required my attention, more particularly, as well as Mr. Jagdeo, but the country is well aware of the series of events that followed those elections and how intense they were and time-consuming that they were. We had to go through the whole Mingo ordeal, then we had a series of court matters, and we had to attend to that. Then the recount came, and then we had a whole series of court actions. You had to deal with GCOM, you had to deal with the international community, and most importantly, COVID stepped in. And lawyers' offices were closed during that period of time. In fact, my office was closed for a longer period of time than most lawyers because someone began to spread a rumor that I had COVID. And the court was not hearing me and were not permitting my staff to transact business at the registry for a number of weeks. So we had to get over that. And in the whole melee of what transpired, a defense was not filed, though one was drafted and is in the file. No notice whatsoever was ever sent to us informing us that the defense was due, and then an application was made a year after, in March of 2021, for default judgment. The normal practice is that that application is normally served on the other side, so that the other side can get an opportunity to come forward and offer an explanation as to why the defense was not filed, rather than take that ultimate step of granting judgment against a party without his knowledge and without his lawyer's knowledge and in their absence. That is not a normal thing in my view. That was not done here, and judgment was obtained. Significantly, there was no hearing also to assess the evidence. So how did this judge arrive at the sum of $20 million? In the ordinary course of things, evidence is required to be assessed by a hearing, to which even a defendant who does not have a defense on the file is entitled to be present and is entitled to interrogate that witness who is going into the witness box to give that evidence against him. From the record that I have examined of the court, that process did not take place. So the bottom line is, I don't want to go more deeper into the legal processes. The bottom line is that active steps are being taken now to have that judgment set aside. And it's not a case of negligence at all. There are very, very extenuating circumstances which one can put forward to a court to excuse the non-filing of the defense, and that is what is being pursued now. It's not the first time that default judgment is granted, and once a good case is put forward as to why a defense was not filed, and appropriate orders are made to rectify that default, normally a court would grant that indulgence or that right, if you wish, to the other side. We are hoping that that transpires here and we can get an opportunity to file the defense, because Mr. Jagdeo has a good defense to this case, and we hope we get an opportunity to put it before the court, and then the court can adjudicate upon it and we take it from there. But we will not leave a default judgment on the record. We will attempt to have it set aside and for a defense to be put on the file on behalf of Mr. Jagdeo.